Good morning. My lady, the Chief Justice, my lady, the Deputy Chief Justice, my lady and my lords, Justices of the Supreme Court. Your Lordship, Your Ladyship, Justice of the Supreme Court, Njoki Ndung'u, you have asked, there are express provisions on quorum for Parliament to conduct business for this court to sit. That's at Article 121 and Article 163(2). There is no express provision for quorum of the IEBC and indeed the other independent commissions that are established under Chapter 18 for the basic reason that the Constitution provides for the commission's minimum and maximum composition. It does not provide a specific number of composition under the Constitution as it does for this court, which is 7, and it does for Parliament and for Senate, because those are specified in the Constitution. Hence, the ability for the drafters of the Constitution to set the quorum as they intended during the drafting. Now, what is the purpose of the minimum and maximum? And I think that is related to the question that has been asked by His Lordship, Dr. Wanjala, and His Lordship, Justice Isaac Lenaola. The engine, the two engines that I spoke about, the Constitution and the statute. The Constitution did not specifically provide for the set number of commissioners. It therefore could not provide for the set number in terms of quorum. That is why the Constitution, under 88(5), says that the Commission must operate on the basis of the Constitution and the legislation. And in the legislation, Parliament, in its wisdom, sets the composition as it did, currently at 7. And set the quorum in the schedule at paragraph 5, whose deletion or repeal or declaration of unconstitutionality is core to the dispute before this court. And I will clarify for my lady, Njoki Ndung'u, Justice of the Supreme Court, that it was not my suggestion, at least not to my recollection, that we need to read quorum into the Constitution. That seems to be the implied suggestion from the submissions of the IEBC, that we should read the minimum of 3 as the implied quorum for the Commission.
We will give you another 3 minutes, but please don't rehearse. We have what you said in the submissions. Just stick to answering the question.
Thank you, my lady. That was the IEBC's submission. Our submission is that you cannot imply quorum based on Article 251, which provides for a minimum of 3. His Lordship, Dr. Wanjala, asked if Parliament, in its wisdom, sets the composition as 3, which is the minimum provided for by the Constitution, and sets quorum at 2, I disagree that it could set quorum at 3 because that would be a unanimous decision, and quorum is the minimum number required to make a binding decision. Would that be bad law? If Parliament, in its wisdom, did that, went through the legislative process, gave an opportunity for public participation, had the views, and did that, and no one challenged that constitution of 3 in a court of law, and there is no decision of the court that finds it to be unconstitutional, then it would stand as good law. But as we speak, the section that provides for the constitution of the Commission has not been changed. So quorum cannot be a minority of that set composition. And I would like to end there and bring to this court the current situation. If you were to take the submissions of the IEBC and confirm or put it as the position in law that the quorum can be 3 because the composition can be 3 as set as a minimum in the Constitution, what you will be saying is that the Commission, as currently composed by statute, would be bound by a decision of the minimum membership. But what is most important, my ladies and my lords, is that alongside the declaration of unconstitutionality of paragraph 5 of the schedule was a declaration of unconstitutionality of paragraph 7 of the schedule, which said that where a unanimous decision is not reached, then the decision of the majority of the members present and sitting would hold as a decision of the Commission. As it is now, therefore, there is a lacuna, if you were to take the arguments of the Commission, in the law on that question, so that we are going to a point where 3 commissioners will say, our decision can bind the Commission, whereas on the other hand, 4 commissioners would say, we are the majority, our decision ought to bind the Commission. That is the risk that we are at, because the flight went so far away from the flight path with 1 engine and passengers inside it. Do not forget that. I urge this court not to forget that. We will have that situation, and I do not think it is in the realm of imagination, where 3 commissioners will say, we stand, and 4 say, we stand. Thank you.